Afra Raymond, good to have you with us this morning. Thanks very much for joining us. So here we are talking about the issue of public procurement legislation, something that has been bouncing around for the better part of 9 years now. And we're going to spend some time this morning discussing all the various issues related to it, and indeed probably expanding our discussion, because at the end of the day, it's all about good governance in Trinidad and Tobago for the benefit of all the people of Trinidad and Tobago.
But I want to take a small point for you. You mentioned about 9 years, a 9-year process underway here. And I want to say to you it's a little more than 9 years. And what's interesting about it, because there's some really fascinating junctures, is that at the moment, one of the big things occupying the public attention is the collapse of the Piarco airport prosecution in Piarco case number 1, when DPP Gaspard withdrew the case. Now, those allegations that are the root of the Piarco case are things that took place in 1998 or so, 25 years. And coming out of that, 3 members of the Pandey administration, Mr. Trevor Sudama, Mr. Ralph Maraj, Mr. Ramesh Lawrence Maraj, 3 senior members, refused to go along with it and said to Mr. Pandey, this is nonsense. We are not voting with you. And the Pandey government collapsed in office. And those are the background facts that got us to where we are here. As a result of that collapse and the political hubbub and so on, Mr. Patrick Manning came into office, around 2001. And there are 2 things Mr. Manning did, coming out of the tremendous public concern over the Piarco airport fiasco. The first thing he did was that he appointed a commission of inquiry under the late former Chief Justice Clinton Bernard, the Bernard Inquiry, to look into the Piarco airport fiasco. And the second thing he did, he appointed a working group to prepare a white paper on public procurement, which is before I became involved in JCC, which included my colleagues, Winston Riley, Carla Herbert, Boyd Reid from Transparency, senior colleagues who were in those meetings. Okay. So Mr. Manning put 2 important things in place, flowing directly out of Piarco from 98. The Bernard report, which has never been published, into the Piarco airport fiasco. My colleague who was on the Bernard inquiry actually said, that is Victor Hart, former head of Transparency. Victor actually said, if we had followed the recommendations of the Bernard report, we would never have had call a hard situation with Unicourt and Mr. Manning. We'd never needed to have had enough inquiry. And we would have had the procurement law a long time ago. That report remains buried. And I want to take chance to ask the DPP, can we please have that published? Okay? And we go forward and we come to the white paper on procurement produced by that working group Mr. Manning appointed. And that white paper was published in 2005, just 18 years ago. And that white paper was laid in Parliament, it's in the Parliament white paper on public procurement in the Ministry of Finance website. And that is what laid the foundation for us in 2010 to write the procurement law and submit a complete procurement law with regulations to the Parliament on the 22nd of December 2010. So it's been a long road. It's longer than 9 years. It's been a long road. And it's all rooted in what seems to be a very old, cobwebby kind of case about the airport and whether it's too old and so on. It's all rooted in there, how we got here.
So, Afra, what is this issue that we're talking about here in relation to public procurement legislation? It can all get very involved and very detailed, but essentially, what is it all about?
Well, the issue really is that there's a public procurement law that we wrote, we being the private sector civil society group led by the JCC. And we lobbied for that law. It's at the point where the law has been passed by the Parliament on the Act number 1 of 2015. The current PNM administration has amended that law 3 times. And the regulations of the law, that those are the things that operationalize the law, those regulations were passed in February 2022. So in legal terms, we are ready to proceed. Where we are at the moment, sad to say, is that we are facing a constitutional imbroglio that is a threat to the public interest in this matter, because the Attorney General has obtained advice from the judiciary which casts doubts on the procurement law. And I call it a constitutional imbroglio because the judiciary, in my respectful view, was completely out of order to render an opinion on illegality and the actual philosophy behind the procurement law. The time for that is past. That is called the legislative process. The only opinion the judiciary could have on a law at this point, properly, is an opinion on a matter coming before them in terms of a case law. An opinion delivered from the bench. The judiciary can have no opinion now. It's way too late in the game. It's severely out of timing. And in fact, the action of the AG in soliciting that opinion and the action of the judiciary in providing such an opinion has acted to undermine and delay the procurement law. We need this law like yesterday. If you look at the amount of money that is being stolen and wasted in our country, we need this law like yesterday. And what we have at the moment are two top office holders, the Attorney General and the judiciary, two top office holders doing a dance, the actual outcome of which is a delay to this very important public law. And that is why I call it a constitutional imbroglio.
At the end of the day, the big puppies will still get away scot-free, whether it's the AG or the legal fraternity or whoever. How the public procurement legislation, properly enacted and enforced, actually serve the public good?
Well, the first thing is that it deals with the question of waste and theft, because the public procurement law properly enacted, which is what I'm campaigning for, the public procurement law properly enacted will actually bring a stop to the amount of bubble and commerce that happens. And I will give examples as we go through the interview. That will then make money available, because it's not only about money. I'm coming to the second point. That will then make money available for other pressing social needs in the country. Okay? And the other point I want to make, the first point was about the amount of corruption, the amount of money. The other point I want to make was a point about order, because there's a phenomenon we have, that some of us call it economism, when you describe something only in terms of money. So in fact, you know the price of everything, but the value of nothing, to put it in the words of a former philosopher. And that is the danger we are dancing with here. Everything is economism. Whether the airport case was $1 billion and whether Clico was 25 billion and so on and so on. But in fact, what is at stake here, Fazeer, as you have said, what is at stake here is a question of good order and social order. If we have a society in which wrongdoers prevail, wrongdoers have more money than you and more money than me, and they can get away with it every single time, we have a society that is fundamentally destabilized. We have a society that is on a path to anarchy.
Well, the point is we have that already.
I know, and that is why we have to fight to stop that.
Okay.
Absolutely. We're there.
Okay,
we're there.
The point
and that's
is
the importance of the campaign.
Look at your advocacy in relation to Clico.
Yes.
2009. Here we are in 2023.
Yes.
And in today's newspaper, you are a reporter that's commenting on the situation.
Yes.
Why no charges? No charges laid at all. Doesn't that tell you, Afra Raymond, as much as your advocacy must be commended, that you're just spitting into a hurricane?
Well, whether it was out of our various positions of hardship and oppression in the past, other people spat in the hurricanes, and other people made sacrifices, and other people did things that at the time, people around them might have said, what is he really doing? What is she really doing? This doesn't make any sense. The forces against us are too great. But you've got to identify what is the decisive thing to do, identify what is the correct thing to do, and work for it, which is what the work is about.
What should be happening? What should we be seeing taking place if we're talking about institutions and professional organizations that we would like to pretend are really interested in the good of the country? Yeah. What should be happening right now?
Well, let's talk about it. You started off by talking about institutions. And the first institution I would speak about in this regard is the judiciary. The judiciary has a very important function within our separation of powers. We have a state. People confuse state and government all the time. We have a state that is philosophically understood to comprise three limbs. There is the legislature, which makes the laws. There's the executive, which runs the state, that is the ministries and WASA and TNTech and those things, yes, the cabinet and so on. And then there is the judiciary, which operates the courts and the legal system to superintend everybody else. Here we have a situation in relation to the procurement law, where the Attorney General wrote to the Chief Justice seeking a checklist of things that the judiciary will need to do to implement the law. He gets back a 29-page document. So he wrote on the 12th of April 2022. He gets back on the 25th of May a 29-page document, which I now have possession of. We now have it's been published. And most of the 29 pages are not taken up in any operational matters, which is what the AG was asking. The 29 pages are taken up with legal objections. No precedents, no research, no documentation whatsoever. 29 pages of damaging speculation about the procurement law would do this, and the procurement law would slow down that. And none of it is founded. So in fact, as an institution, let's talk about it as an institution. The judiciary is now engaged, as far as I'm concerned, in a questionable piece of behavior. And I'll tell you why. Number one, you were not supposed to comment on a law that had already been passed.
Okay, but it's my point, Afra.
Yes, sure, you go right ahead.
The point is, well, why didn't the AG just simply say, well, I didn't ask you for that. So I didn't ask you for that. I asked you for something else. You come in with all this tralala. I didn't ask you for that. So that's irrelevant. Let's move on.
The question you're asking, why didn't the AG ask that? I'll come back to that question. So the first thing is that they crossed the line in giving an opinion on a law that was passed. There's a press release of the 5th of October 2022, a press release of the judiciary, in which they talk very deceptively about there's a tradition about the judiciary commenting on laws that are pending, and this is a long-standing tradition and so on. And while that is true, it is what you call a tautology, a true statement that makes no contribution to understanding what we're discussing. Yes, it is true the judiciary has commented on pending legislation, but the procurement law is not pending legislation. It's nonsense to say that in a published, prepared press release. Second point, the objections that were made were baseless. And third point, no research was even presented or attempted to present research. Why did the AG not make the question you're asking, why did he not just rebut it and say, listen, I didn't ask you for this? I have actually gone to court to ask for that actual letter. What actually did the AG write to the CJ? And what actually was in the CJ's covering letter to the AG? And would you believe me, since about October last year, which is coming on 6 months, we've been in a battle back and forth, and they don't want to release those two letters. They've released a 29-page document, which is quite pitiful, really. But they do not want to release that exchange.
But doesn't that...
And that actually is, I'm in the High Court now. I'm saying we, that's me, I'm in the High Court now. That actually will uncover the question you're asking. But it's really an important, relevant question.
But doesn't that tell you, Afra Raymond, the thought process of these presumably professional, high-minded institutions, that you have to go to these lengths to get information that are really about the public good and governance? And it's almost as if you're saying that, this behavior is what you would expect from low-class operatives who are seeking to hide their behaviors.
Yes. My hashtag for that, to use the language of the Twitter dome, my hashtag for that is hashtag morals of a mango thief. So the kind of person who befriends your dogs, climbs your wall, steals all your mangoes, and when you come in out and you stop by the junction, they will offer to sell you those same mangoes. Look, Mr. Fazeer, you have some nice mangoes. You have nice heaps,
I'm sure I've bought my own stolen zabuka many times.
Yeah, you see? So it's a reality.
What you're saying is that the judiciary are no different from a bunch of zabuka and mango thief?
Well, morals of a mango thief. And then we can move, because we're talking about institutions, let me move to another one, which is the Law Association. I saw this morning in the newspaper, on the front page of today's Guardian, that the Law Association president, I think Sophia Choate, senior counsel, has in fact announced that they're going to try to have some sorts of meetings or to mediate the dispute between the Attorney General, the DPP, and the Chief Justice around the whole question of the DPP's operations and that sort of thing and so on and so on. And they were offering to mediate, and in fact they use the word imbroglio. But what is fascinating, and it's a learning moment for all of us who are not part of that circle, and for those people who are in the circle and you think nobody's looking at you, somebody's looking at you, you aren't the only learned ones. Some of us out here, we are not learned, but we are educated. Let me explain it to you all. The Law Association, I've been lobbying them. including Sophia, for us to have some sort of a meeting, a seminar, a discussion about the constitutional imbroglio, which I outlined, between the Chief Justice and the Attorney General on the procurement law, because ironically enough, you see, the whole thing, the whole spat emerged out of the decision of the DPP to drop the Pianco case. Yes?
Right.
And then he dropped the case against Ramdean and Ramlogan because of Vincent Nelson, King's Counsel. He changed his opinion and so on. And there's some major anti-corruption cases that were dropped. Because ironically enough, those individual cases which are now taking up the headline, the Piaco case, Ram Logan and Ramdean, the DPP, Dr. Rowley, the building on Park Street, all of those cases come under the umbrella of the procurement law. If we had a proper procurement law, we could get past this constitutional imbroglio that is blocking the procurement law. We wouldn't have to have any of those cases again.
But there you have the answer to your question.
Yeah. So in fact,
it's big people saying about themselves. So it's like a Tantan and Saga Boy, they're really dancing around, performing their role in this grand masquerade.
Of course.
Saying about each other.
Of course. Yeah. And the point I wanted to make, to put all this into context and to give it meaning, because we can describe a thing, and then we have to describe the meaning of the thing. Analyze and find the meaning of the thing, is that the Law Association, the lawyers in the country, that fraternity, received a beneficial exemption from having legal fees under the oversight of the Office of Procurement Regulation. They received that exemption in the third set of exemptions PNM made, 8th of December 2020. And what that means is that they were beholden. The Law Association, the fraternity is beholden. Okay? Because what is given can be taken away. So if you give too much trouble, Mr. How is his name? Mr. Imbert? Mr. Imbert, yeah? He could take it away if you give it too much trouble. And therefore, it becomes a rod, a sword of Damocles, a rod held over your back, a go whip held over your back. So in fact, the Law Association has nothing to say about procurement. They're concerned about the imbroglio, they're concerned about the DPP, they're concerned about one building. But in fact, the case, all of those cases could be extinguished and we could have a new future for the country if people inside the Law Association, I know some of you in there have a conscience, you know who you are, I know who you are, to stand up for the correct thing. You were able, in the case of Attorney General Reginald Amor, with that case about the false affidavits in the American court, you were able to call a special meeting of the Law Association to put a vote of no confidence on him and extract an apology from him, and no further action was taken. But essentially a principle had been set. In the absence of a law, you were able, as an act of good conscience, to call the man to account, our Attorney General. And I want to put it to the Law Association colleagues, the ones out there who have a conscience, the ones out there who are edified. I want to say to you, you are also able, as a decision, to hold the Chief Justice and the judiciary accountable. I have it on good authority, and I'm speaking about judges who've spoken to me directly, that the judiciary is not even aware of that 29-page position. There was no discussion, there was no seminar, they didn't agree any position. A position has been taken in public under the letterhead of the judiciary, and there are people on the bench who don't know what the position is.
So why you don't speak out? And this is my point, Afra Raymond. I'm fed up hearing about these people with a conscience and so on who will pull you in a corner. Yeah, well, Afra, really, you're right on this point here, but you had to be careful, so on. So I can't speak out because I will jeopardize my position. So what is the point? Why is it that it's easy to go after the low-hanging fruit? It's easy to target the young, the vulnerable, the misguided, pelt them and let them rot in remand for years. But yet, when we're talking about billions of dollars of our money that has gone in the pockets of undeserving individuals that could have built a proper nation, and you are telling me that you don't want to say anything to jeopardize your own position, who is the criminal here then?
Yes, I understand. It's a very serious struggle. So it's a serious struggle for the soul of the country, a serious struggle for the future of the country, and the Law Association colleagues. You've made some steps today. Well done. Calling for the meeting, and you want to try to bring the parties together to discuss this imbroglio with the AG, the Chief Justice, and the DPP. Find your moral fiber. Look for it and find it. Have your conversations with each other. You know who you are. I know who you are. and let us have a special meeting. Use a convocation hall of the Hall of Justice and call the Attorney General and Chief Justice to account on this question. What the dickens is going on? How could he write a 29-page paper with no supporting research? I'm a subject matter expert, and I can tell you there is no supporting evidence for that. You couldn't go to the court in Trinidad and submit something with no evidence. The judge, any judge would quite rightfully pelt it out. And that is what is flying now in the face of our country's progress. The Attorney General can say he's holding out because he has 19 objections that the Chief Justice identified in the 29 pages that he didn't ask for. But the letter of what you asked for, you're resisting me in court. But we will have our day in court.
You mentioned anarchy.
Yes.
I would suggest to you, Afra Raymond, that we have already gone past the point of collapse, institutional collapse. Although people say, no, compared to the other territories, other islands, we're in a much better position, even financially and so on. The lack of trust, all these big institutions, and they intimidate you with the positions that they hold. For that, thankfully, you have the resources to challenge matters in court. Mm-hmm. But how many people do? Yeah. If I were to say something untoward or libelous or slanderous or whatever, they drag my tail in front of the judge or whatever. I don't have the resources to challenge them. I don't have the wherewithal to frustrate the process. And that's the enemy. Yeah. So this is what we are dealing with. I fully accept all of the specifics and the details and so on. Oh. But if at the very core, you have influential decision makers in positions of authority who have no problem with protecting their own backsides before anything else, then where are we going?
So it's a pull and tug. It's a call and response. It's a pull and tug. We have to pull and tug with each other, and it's a fight. I agree with you. It's not a straightforward thing. It's a very serious fight that we have to get engaged in here. Let me give an example of something, Fazeer. We have been speaking about one of the recent issues was about the DPP and the office at Park Street that Royal Bank used to be in. And that in fact, Dr. Rowley made a complaint. I think it would have been on a political platform. It's sometime in the last 2 weeks. He made a rather strong complaint. He's a gentleman who speaks very strongly. He made a complaint that, in fact, $45 million had been spent. And a newspaper article came out on the 11th of March from the Express, Anna Ramdas. And Anna spoke about the fact that the building, $21 million in rent had been paid in 3 years. So the government took possession of the building in July of 2020. That, in fact, $24 million had been spent to refurbish the building and modify it. It's interesting because the building is 23,000 square feet and the rent is $600,000 a month. $7 million a year, $600,000 a month. And that is $26 a square foot. And there's never been any rental report of Spain of that size of space, that amount of space, for $26 a square foot. That's crazy. Much less the location. That is probably one of the worst blocks in Port Spain. And then lastly, you pay a top rent and then you spend $24 million to fix the building. So there is something very, very seriously amiss. And it's kind of ironic because it's clear to me, even if he doesn't agree, he has the right to disagree with me, I can disagree with him. It's clear to me that the statement about the DPP's office and him not taking use of the office and so on was made to level a serious criticism against DPP Gaspard. That is what was played out there. But what is interesting is that having talked about it, and the media having gotten some details, and I could apply some analysis to it, it's clear to me that there's a far bigger scandal that's visible there. How did you possibly agree those terms? Nobody in Port of Spain pays more than $20. $15 is a very high rent. How did we agree $26 in 2020, in the middle of the COVID?
Well, I have the answer for you, Afra Raymond. This is the land of bubble without consequence. And this is the thing. The absence of consequence in a place like Trinidad and Tobago, going all the way back to the Caroni Racing Complex and the crash program and the gas station racket and so on. The absence of consequence has brought us to this place where powerful people with powerful connections who essentially govern this country can act with impunity. It's as simple as that.
It's very serious, and that is the reason, because this is now taking on some dimensions in terms of seeing the constitutional imbroglio in relief. That is now bringing into focus the necessity for us to defend and promote independent offices. And I could say that in developing the procurement law, one of the things, and you could look at it as a weakness, but one of the features of the law is that when a case is developed against somebody, it has to go to the DPP for them to appoint someone to prosecute the case, because it's a criminal matter, it's a crime. And we had discussions and dialogue with the DPP, which is the current individual who's there. And I'm convinced that exactly a person who's a conscientious public servant working in the public interest. I mean, I've had meetings with him on other things. I don't see DV Gaspard as one of the people I have a question mark over, unlike some of the others I spoke about. So it is imperative in this situation that we defend the independent office holder who has a spine. Okay? It's also important, while we could show our respect, which I just did, while you could show your respect and your regard, it's also important when is it necessary to blow the whistle and hold up your finger, like I did in this morning's newspaper, to say to DPP Gaspard things that Dr. Rowley did not, and say to him, like, hello, CL Financial collapsed in January of 2009, which is 14 years ago. The report of Coleman was delivered to the Parliament on the 1st of July 2016, which is 6 to 7 years ago. And we were told by the Prime Minister that the report on CL Financial could not be published because you, DPP Gaspard, had asked the government to hold its hand and publish the report because that could jeopardize criminal prosecutions. And I think the public, we need to hear from you. What is happening with those criminal prosecutions?
But where's the clamour? I mean, you're making noise about it. You are pursuing the matter. Where's the clamour? Where's the clamour from those institutions and organizations or even individuals who proclaim that they are interested in good governance and are there for the welfare of Trinidad and Tobago? Where are they?
Transparency. You see?
As I said, from the very outset, your advocacy has to be commended. And in fact, I remember interviewing you from even the days up at CNMG when we talked about CLICO and this secret society, this culture of silence.
Code of silence.
Correct? Yeah. It prevails. And in fact, it's enforced, it's reinforced. Now, because it is quite evident that this works in a place like Trinidad and Tobago. Just stay quiet, lay low, and wait for it to blow over. And then some other thing will come up that will distract attention. And by next to that, people will forget about it. And there will be no clamour at all. You'll get away scot-free.
I know. We have to break this cycle. And I want to say that it's not... The reason that we are in this cycle is not as a result of our size. Because one of the misnomers people put about is that the society is small. And in a small society, people know each other. And we don't wish to do harm to people we know. Therefore, we find a way to, and I don't agree with that. I mean, there are examples up and down the Caribbean of other countries grappling with some of these same issues that have done better without any American intervention or the Canadian. They just have a system that works. And they will deal with somebody who has crossed the line, they will deal with them and put them in prison.
Are we fundamentally corrupt?
Well, there's some kind of moral fiber. That's why when I was speaking to the young people in the Law Association, I made a call to find your moral fiber. You made a step, you're going to have a meeting about the DPP and the CJ and the AG, and that's important. That's an important step you all made. Congratulations. But find your fiber, because the big issue is the procurement law. And the big issue for us in understanding this imbroglio within the Law Association is the Law Association has achieved a valuable exemption which could be taken away. And that go over with is what have all your behavior. So I'm saying it plainly. Okay? It could be taken away. What is given could be taken.
Just on that point.
Sure.
You've been granted an exemption. So does that mean you surrender all of those concerns and just because in other words, you get away? Nobody going to be watching how public funds have been used for the lawyers and so on.
Yes.
So you get away.
Yes.
So because you get away, that's all you were interested in, basically.
Well, yes, it seems, and I'm using the word seems because, of course, any one of them could make a public statement and explain what it is they're doing. Because I could tell you somebody involved in this campaigning, and we were writing the law and campaigning for the procurement or writing it, campaigning for it, and so on. For years, I could tell you that, in fact, in all those years, we've never had any interest in the law association. We've never been able to get it. I mean, I had different people I was very friendly with who were presidents, Jairam, the late Dana Sitahal, and so on and so on. We used to have lovely conversations about it, but they didn't want to have a meeting. They could never muster the interest to have a meeting about procurement. And in our view, as a group that created the law and lobbied for it, that law, that single law, is the most important law in the country after the Constitution, because it has a really transformative effect and impact to change just about everything the way we do things in the country, not just at a financial level, but at a moral and organizational level, that in fact, if you do things the correct way, you will prevail. And if you don't do things the correct way, you would not prevail. We need to put back that in the system. That's how important it is. It's a fundamental thing to fight for.
Go the way of being idealistic.
Sure. It's a Saturday morning, yeah.
Yeah, why not? Beautiful Saturday morning. The AG wake up Sunday morning and say, really, I should tell the judiciary where to go with the 29 page or whatever, and really push this thing forward. And it becomes operationalized. But then you have, again, the various institutions who have everything at stake. They have their lawyers piling in, blocking this, blocking that, blocking the other, frustrating the process. We have people with the Piarco Airport inquiry who've made jail and have served their time in the United States. But here we are in Trinidad and Tobago with cases 1, 2, 3, and 4, or whatever. Four. Collapsing. What I'm trying to get at is that even if it were to be operationalized, what makes you so confident, Afra Raymond, that it would actually serve the public good in the end?
Well, there are 2 or 3 things to understand about the law that are different than what we have at the moment. Because what we have at the moment, and this is a very interesting way you come at me here, because the 29-page document the judiciary submitted to the AG has a lot of rambling and stuff that's unsupported and so on. But at the bottom of page 5, there's a when you read it carefully, I read it many times carefully, when you read it carefully, the bottom of page 5, there's an extremely pointed observation. The judiciary says, and they're trying to warn the AG against implementing the law. They say, use the phrase, operationalization of this law in this form would actually threaten the operation of the judiciary and other state bodies. What I translate that as, literally I translate with the plain words of the paper and you translate. How I translate that is that the judiciary is warning the AG that in fact the law that is before us, the one that's about to come into operation, actually threatens to disturb the existing arrangements. And that is his alarm. His alarm is, wait, this law will disturb existing arrangements. Watch out. The AG appears to have taken it on because he said he delayed it. And I want to say, as one of the people who authored that law, we are practitioners and we know what the problems are. We know what the problems are. We recognize that the problems the country is in, the cascading series of crises our country is in as a Caribbean civilization, is as a result of the existing arrangements. We knew that. Therefore, we wrote this law specifically to disrupt the existing arrangements. So this is a very important philosophical juncture in that 29-page thing.
And you really believe that the ones who hold the reins as far as allowing this process of good governance and accountability and procurement to actually be enforced, knowing that it would disrupt the nice thing that they have going,
existing arrangements, yes.
You really expect them to facilitate it?
Well, we have to fight for it. I agree with you. It's going to be a hard fight. I'm going to come to the point now about how it will do that. You ask me how the law will change things. Let me get to the detail now. I want you to get the philosophical position. Let's get to the detail. So some of the ways things are different. One of the ways things are different is that the existing arrangement for Fazeer is one in which a body like TNTEC or a ministry could be in breach of something, whether it's town and country planning or the stock exchange could have some laws, and in breach of something, they were supposed to do something by this time or that time. And sometimes you will see these things in the papers where the Securities Exchange Commission will put up a notice that the HDC or WASA was in breach of something. And they agreed that they were in breach of the law, and they agreed to pay a fine of $400,000. And it's like called an agreement. So they settle everything by agreement. What is wrong with that is that is how the world financial system is working, all globally. So the kind of crisis we're seeing in the world now. So in fact, a company could be involved in some bubble, some other kind of part of the world, some other part of the market. You see it on TV, and the company hit a massive fine, 200 million US fine, blah, 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 blah. Nobody in the company goes to jail. You don't name anybody who's been charged with anything. The company is assumed to be the natural person that did the wrong thing, and the company pays the fine. The procurement law totally takes a step around that. Our position is this. The bodies that are transacting public money are called procuring agencies. Each of those procuring agencies has to appoint a biological individual who is the procurement officer. The procurement officer is Thomas Ramsing. He has a date of birth, he has an address, he has a DP number, there's a person. That person is signing all the procurement orders, contracts, whatever you call them, awards of contracts and so on. And if something goes wrong, with the exception of one offense, a minor offense, all the other offenses under the procurement law involve prison. The judge must put you in prison. So it's a fine and a term of imprisonment for the procurement officer. So for the first time in the country, we're describing what's different about the law and why it's being resisted this way. For the first time in the country, there's the possibility, the real likelihood that the connection between cabinet and the state bodies, the WASA and the UDCOT and these sorts of bodies could be broken because the chief procurement officer of, let us say, UDCOT, you don't want to take an email from a PS or an email from a minister to do this, to give this person this and to give that person that, if it's in breach of the law. Because when anything goes wrong, you are the one who's going to prison. The law is written in that way. So that corporate veil, that this is what they call it in law, the corporate veil, we figured a way to go around it and to attach the responsibility to a person. So that's the first thing. On the private side, which is also interesting to understand, on the private side, let's describe what happens now and what our proposal is, what the law is. On the private side, somebody could be a building contractor who pays bribes and does shabby work. And they could put up 4 buildings in WASA, and the buildings get cracks after a minor earthquake. And WASA sends a qualified person to look at the building. The person says, this isn't built right. And they go back to the paperwork and they realize somebody was taking money. And this contractor was paying money to get these contracts. And WASA could, and the public bodies in the country have good people who do strike off people. So WASA could strike off that person. WASA could strike off that contractor X and say, listen, X, those buildings have to be rebuilt. And you realize you're paying bribes to Harry, and you can't work for us again. And they send out an order that WASA is not to give any more work to X. The problem in the current system is that X could still get work from the Digomartin Regional Corporation, TNTech, the Ministry of Works, and the Tobago House of Assembly. There is no way for the Tobago House of Assembly to know that X was struck off by WASA, because when they have a pre-qualification procedure, they ask the person who is applying to qualify as a contractor or supplier. You fill out a form with all your details, your VAT number, your PAYE, when the company was registered, all of those details. And one of the questions they will ask you is whether you have any court matters or whether you ever struck off. And in fact, you're asking the person who has the most to benefit from a lie to tell the truth. So they're all going to say no, they never had any matters. The current system, and I'm calling it current because the Parliament has passed the law, it's just for the Attorney General and them to proclaim it. The current system is one in which we have something called a modern thing called cross-disbarment, which means that if X is found guilty in the WASA matter, like the example I gave you, the procurement regulator can actually ban X from any state work for up to 10 years. So, because most of the people in this country are business people, contractors, suppliers, professional services, people give professional opinions and so on. A huge amount of their money comes from the state. So that's something that is a tremendous consequence on that side of the thing too. At the moment, that doesn't exist. So in fact, the procurement regulator could say, something X this is really awful. 2 years you can't get any state work. And that there's a common register of contractors and suppliers. X's name will be taken off of that list. You can't give him any work. So those are some of the differences, and that explains the thinking that went into creating this law, and in fact, the background for the kind of hostility that we're facing, even though PNM has amended law 3 times to suit what they want, which is correct and proper, because that is how the parliament works. I don't agree with all the amendments, but that's how the thing works. They won the election and they put things in place. Even though the law has been amended to suit what they want, we still can't get it done.
Given where we are today, are you really optimistic that the law as an operationalized process will see the light of day?
Optimistic is a strong word, but I battle on. Optimistic is a strong word. I don't think optimistic is really a word I would use. But it's something that you have to keep on fighting, and you have to keep on doing efforts like this to get more people to understand what are the issues. And what is it we're fighting for? We're fighting not just for money, it's not just a financial thing, which I described earlier as economism. It's not just a financial thing. We are actually fighting for a restoration of some kind of order and stability to the society.
From my own idea of a summation, to take it to the level of the young person who might just gotten a university education, with a lot of effort to ensure that they're properly qualified and so on.
Yeah.
But for whatever reason, they don't see any opportunity in Trinidad and Tobago. They don't see a pathway to progress without knowing somebody or having a friend somewhere or whatever. And at the end of the day, they're saying, well, Afra Raymond, your advocacy is to be commended, and on all of these matters that you've brought to our attention in this discourse is very enlightening. But that will change the price of bread.
I understand your point, Fazeer, and it's not something that one contemplates lightly, because at the end of the day, you have to study the process of transformation and the process of how these changes come about. When I get into these discussions with friends and family, my rejoinder to them is that, of course, you have to be focused, and you have to be a focused warrior in terms of what you're fighting for. But you also have to remember history and don't be ahistorical. So it's possible to have a cynical point of view in which one asks, why would the beneficiaries of all this wrongdoing, the powers that be, change the system? Why would they?
That's the point. Do we really expect the people who benefit the most from this arrangement, who actually happen to be the powerful people, the legislators, the business people who benefit the most from this present arrangement, and who are the ones to allow for this thing to really become enforced? Do you really believe that they will actually allow that to happen?
Okay, so the answer, Fazeer, to that pointed question, that's what I expect from you, is that in fact, we have to understand that change is necessary. Okay? We have to focus, we have to fight for it. And we also have to understand the lessons of history. So the group that voted to give women the vote, and there was a movement called the suffragette movement. Yes. Women chained themselves to the railings around Parliament, and there was a whole lot of protests and violence and so on. Quite right, quite rightfully so. But the women getting the vote, the people who voted to give women the vote were all men. And presumably, by that framework, they were all people who were benefiting from the old arrangement. But a moment came out in things when they realized they couldn't stay this way and they had to change. And the same thing with the end of the slave trade, which is something I always think about, and slavery as a practice, and the people who voted to bring that to an end, albeit on rotten terms, with the whole thing with the 20 million pounds that they were being paid for loss of property.
Which raises the question, Afra Raymond, was the end of slavery a humanitarian decision or an economic decision?
Absolutely. But the point is that the people who voted for it were all white.
Seeking their own interest.
Seeking their own interest. And there has to be a discussion that transforms this into one that, in fact, the national interest, and this is really, as I said, it goes back to a philosophical question. It's not just a financial question. The national interest, the developmental interest of the society has to be elevated in our discourse beyond personal things.
What we have here is a situation now with all the things that have happened. DPP, AG, Prime Minister, it just, the Piaco inquiry, the one case collapsing and so on. It just seems so involved. It seems so complex now. How do you assess this particular situation?
Well, I see this as a situation in which senior office holders, I don't want to say collaborated, I would say they've aligned themselves with each other. And I'm speaking about the Attorney General and the judiciary. They have aligned themselves with each other in a manner that what we have before us now is manufactured dissent. So the Attorney General can take a position, something resembling good order. So you can say, listen, I would have brought this law already, which the Prime Minister wants very, very badly, except that the Chief Justice has these objections. And the Chief Justice's objections are contained in his 29-page document from the judiciary that outlines all of these very serious concerns. Of course, we already touched on the point that the judiciary has no right giving comments on a law that the Parliament has already passed. The only place the judiciary could properly give comments on a law the Parliament has already passed is from the bench in delivering a judgment. Judiciary has no right in that. Okay? But let's go beyond that and ask the question. Because you see, I did my research to prepare the regulations for the Office of Procurement Regulation. The Office of Procurement Regulation wrote to something called the Judicial Education Institute, which promotes education on the laws and so on at a high level in the institutions in the society. To ask them for assistance to prepare those regulations that they were in conformity with the best practice in law. The Judicial Educational Institute appointed 10 judges, some of whom have since been elevated to the appeal court, appointed 10 judges. And those judges, each of them was on a whole day at the OPR office, training their seniors in what were the correct things, so the regulations will be written in conformity with best practice. The chairman of the Judicial Educational Institute is the Chief Justice. So what are we playing at here? The CCJ, the Caribbean Court of Justice, they have also had judges involved in training the officers and the seniors of the OPR in accordance with best practice. So what are we playing at here? This is why I call it manufactured dissent. So we're pretending there's a problem. We can't produce citations because there are none. I'll look at the camera and tell you again, there are none. Therefore, we get into an immense pretense that we have some kind of serious concerns. And what we are witness to, because I've issued a challenge and I issued it again here, what we are witness to is when Brer Rabbit and Brother Nancy bunks up and they meet up by the fence, where water is more than flour, where all the king's horses and all the king's men is more than just a primary school that nursery rhyme that is pronounced by little children. What we're looking at is intellectual bankruptcy. And intellectual bankruptcy, for those of you listening, and I know you're listening, intellectual bankruptcy is the inability to explain or defend or advance your cause.
Is it intellectual bankruptcy?
Because there's simply nothing there. And I want to say that is what we are witness to now at the highest offices of the country. That this thing is being advanced as a considered position of the judiciary. Come out and defend your wicked.
But is it intellectual bankruptcy because all of these people bright too bad, or moral bankruptcy?
They're bright for spite.
They're bright for the wrong reason?
They're bright for spite. Yeah. It could be a moral lacuna, but I mean that those are subjects that are for people who are far more churched and templed than I am. I'm not into any of those things.
But I don't see how church or temple or mosque or anything comes into it.
It's a very serious point you're making. It's a moral center that is lacking. So you're putting forward a position with no supports. You put forward senior, respected colleagues to tutor the people on how to get the law perfected. And that was passed by the Parliament. And you are now packing back in 29 pages to say the law is not good. And I'm speaking about the Attorney General and the judiciary. They have aligned themselves with each other in a manner that what we have before us now is manufactured dissent.
Let's say any of these high-placed individuals would watch this interview and say, I know how to take you on, because I know how Trinidad and Tobago operates. You could say what you want. I just had to let people watch it, likes, shares, whatever else it is, thumbs up, thumbs down, and I don't really know how to take you on at all.
My response is to say that, in fact, what we are seeing here is the emergence of a different set of challenges. In the past, coming out of the colonial experience, power was handed down from on high. So the Queen gave power to the Governor General, and the Prime Minister or Premier was elected, and he had power. Trickle down. What is happening now? We have a tremendous flattening. So it has some convulsions and manifestations in different parts of the world. The whole fake news thing and Donald Trump, and Brexit, and a whole lot of stuff that would have been inconceivable 20, 30 years ago. And that has also opened up the field. So you have some silly and detrimental things like Brexit and Trump and so on. But that has also opened up the field for us to question office holders in a way that we never did before. Because in the past, in the good old days, when you had Dr. Eric Williams, those good old days, when everything was okay, you couldn't have this. Yeah, I could make a video and put it out there and 1,000 people talking about it and challenging an office holder. That was simply inconceivable. If you were in opposition, if you identified as an opposition person, you couldn't even get on TDT. Okay, that's how far we've come. So I'm saying this directly to those people who believe we've made no progress, we haven't gone anywhere, and the country is doomed. I'm saying, no, we have made, in my lifetime, and I don't think of myself as an old person, in my lifetime, we've made tremendous progress, and we have to continue focusing on what we want to get, to continue that progress and fight for it.
Well, we hope that you found this discourse informative, maybe infuriating with all the information that may not be entirely new, but it's always good when we get some context to a situation like this that involves public procurement, good governance for all of us in a place that's unique in many ways, Trinidad and Tobago. Thanks very much for sharing this some time, being with us for Discord. You could follow it on afraraymond.net on the many different platforms, on YouTube as well. And we certainly hope that we benefit as a nation, and all of us can benefit from a discourse like this.